Yeah, we can see it. Yeah, I've seen it before.
You've seen it before. This is the first time that James has seen it. I've given some of your information to David Gibb. He's our presenter. Just to give you a little bit of background on David Gibb. He's been with the company for many years now. He's the vice president of accounts here. He goes out on the road and speaks for Legally Mine as well, gives these presentations, as well as these webinars from time to time. More importantly, he really understands the necessity of asset protection, having owned several businesses in the past, having had assets, and so I want to thank him for his time. And with that being said, I'll go ahead and let him take it away.
Thank you, Garrett. I appreciate that. And Harrison, James, can you both hear me okay?
Oh, yeah, we got you.
Great. Okay, and if I understand right, so Harrison, as he said, you'd seen the presentation, and Garrett was not clear on if the two of you are business partners or not. Is that, or is it in? I don't know. Can you explain your relationship?
So he's an independent contractor, and I own the building.
And this is James who's speaking?
Yeah.
Okay, all right, great. Okay. So you own the building, he's an independent contractor. Okay, great. And then James, what do you do for a living?
I'm also a chiropractor.
Oh, okay, all right. So chiropractor, do you own your own practice there as well?
Yeah.
Okay. All right, great. And then he put down 3 children. Was that for James or for Harrison?
That'd be Harrison.
Harrison. And then James, do you have any children as well?
Yeah, I got 2 kids.
Okay, all right. Just kind of get. And then what state are you guys in?
We're in Utah.
Oh, you're in Utah. Great. Okay. Awesome. Well, good to have you on the phone today. Apologize for some of the little technical difficulties we had. Garrett is actually on the road today, so it was difficult to try to get him on. But anyway, glad to have an opportunity to spend a little time with you today. You know, I love speaking with different medical professionals and chiropractors in your in what you do in helping clients, helping people to feel better. And I really feel like, as I talk to different groups of people, that you get to live the American dream, and not only that you get to own your own practice, but if you do it right, you can be a high income earner. There's, you know, obviously there's some negatives that go along with that, though. One of the big negatives is obviously here in the United States, we've got an epidemic of lawsuits, and I think you're probably aware of that. It's, you know, here in the United States, folks in your profession are going to have a large target on their back. And you have to understand, you can bring a lawsuit forward anytime, anywhere, for any amount of money here in the United States, and there's nothing you can do to prevent the cause of a lawsuit here in the United States. But what you can control and what you must control is the motivation in these suits. So we're going to talk today about what that motivation is and how you can eliminate the motivation, because if there is no motivation, there won't be a lawsuit. Now, Legally Mine's been around for about 40 years now. When we went out in the beginning, we would go out and educate doctors, and eventually we evolved into something else. As the founder of our company is an attorney named Jay Minton. Jay Minton is considered the father of asset protection here in the United States. Most of the legal tools used for asset protection were created by he and our staff, including the creation of the LLC. So we're going to talk today about how you can use the LLC not only for your practice, but also for your personal assets as well, and we'll get into the details of that. Now, through the years, we get to know a lot of different people, and one of the gentlemen we met was a man named William Danko. William Danko is co-author of the book, The Millionaire Next Door. Have either one of you read the book or heard of it before?
Yeah, absolutely.
Oh, okay, all right. Well, premise of the book is pretty simple. A couple of college professors went out to find out what made millionaires tick, why were they wealthy, and they found some interesting things. They found that most millionaires don't live in huge homes, don't drive big fancy cars, but what they do is they spend less than they make each month, and they would reinvest that money, the money they were saving, and eventually that money started working for them, and that's how they created their wealth. But they also found that they looked for ways to save money on taxes. And so we're going to talk today about, through entity structuring for asset protection, there's actually some great tax deductions that are available to you that are slam dunk easy to take, and we'll get into the details of that as we get going. Well, Legally Mine, a few years back we had a family physician come to us. He'd been in practice for about 30 years. One day he sent his secretary out for sandwiches. While she was out, she ran a red light, hit 2 high school girls on their lunch break, and unfortunately killed them both in this scenario, in this story. And the girl had insurance, and it paid a $1 million death benefit to each one of the families of the deceased. However, the attorney that was able to secure that death benefit started looking around the situation a little bit further for deeper pockets, and you can guess who he found. By the way, this doctor's name was Dr. Allen. He'd not only been successful with his practice for 30 years, but he'd been buying some real estate. So he had a portfolio to go along with the practice. The attorney said, that's where we're going to get our money. Filed a wrongful death suit against Dr. Allen. Immediately he did what any of us would do, ran to his attorney and said, save me. Well, the attorney took a look at it and said, you need to settle this as soon as possible. He said, okay, what's that going to take? And the attorney told him, unfortunately, in this case, it's going to be a few $1 million to settle this. Well, Dr. Allen, he just said, how can I possibly be on the hook for a few $1 million? All I did was simply send my secretary out for sandwiches. And the attorney told him, you have something called vicarious responsibility, where you're responsible for the actions of those you direct. Now, it sounds like, James, you're the practice owner there, and then obviously, Harrison, you working as a 1099 or an independent contractor. Both of you are in a very risky position. I think you understand that as you direct people, as you work with people directly and so forth. But understand, direction to a secretary, reception, an assistant, they make a mistake at your direction and they get sued, you're going to be named as well. In the case where what we're talking about with Dr. Allen sending the sandwiches out, he directed her to go get the sandwiches so he could be named in this lawsuit, and it's through vicarious liability that can happen. As practice owners, it's automatically and so this was the situation that Dr. Allen was in, and he said, I've been in practice for 30 years. If I lose my practice over this, I'll just go ahead and retire. And the attorney said, well, that would be fine, but they're not just suing your practice, they're suing you as well. You see, here in the United States, if you have a closely held corporation, the judge can pierce the corporate veil and now go after all of your personal assets as well. And that's kind of a scary thought to think about, that our personal assets are at risk. That's why we created the company, is to protect those assets, the personal assets. But through this provision, they can absolutely pierce it, and they do it all the time. Now, let me give you the definition of a closely held corporation. It's any corporation with under 100 shareholders. Well, that's 99.9% of the practices out there. And so the risk is real, and it's there. Most of us don't realize that, and this was the situation Dr. Allen was in. And he had a decision to make. Should I go ahead and settle this or go ahead and fight it? And he decided he was going to fight it because he reasoned that there was no jury of his peers that would ever convict him. All he simply did was send his secretary out for sandwiches. Well, he had his day in court, and that day the attorney got the jury on his side in a big way, and they won a $30 million judgment that day. He literally lost everything. Lost his practice, took his building, his equipment, everything inside the practice. But because it was a closely held corporation, the judge pierced the corporate veil, took his home, took his checking accounts, investment accounts, cash, jewelry. Everything was taken in this lawsuit and really devastated him and destroyed him to the point where he had to go to work as an associate to a friend of his just to get by, only to find out he'd have his wages garnished for another 7 years to fulfill on this judgment. It really was a bad situation. And when you look at this, ethically, did Dr. Allen do anything wrong in this case?
No, obviously not.
Yeah, of course not, right? Just send his secretary out for sandwiches. So was this lawsuit about righting a wrong, or was it about money?
Yeah, it's simply money.
It was all about money, and if that's the only thing you learned today is the lawsuits are always about the money, at least I feel like you've learned something, because it is always about the money, and a lot of people tell me, well, if it's about the money, I'll go ahead and get rid of all my assets. Well, yeah, and that would work, but most of us want to have a home and want to retire and want to have some cash available and get some nice things, and so it's not a very practical way to do that. Other doctors I talk to say, well, I'll put them in my spouse's name. Don't do that. If you get named in a lawsuit, your spouse will be named as well as any possibility for divorce, separation. They get in an accident themselves. It's not a smart way to protect your assets. And so, really, the best way to protect your assets by far, with the most flexibility, is to put them into entities That is by far the best way. Now let's go ahead and talk about this and explain why this works and how it works. But first, let's talk about asset definitions. Your screen should have advanced. Did that do that for you?
Yes, it did.
Okay, all right. Well, there's high risk and then there's safe assets. A high risk asset can create a lawsuit on its own. This would be like your car. Your car is a rolling lawsuit waiting to happen. You can hit somebody, hurt somebody, and you can get sued over that. A safe asset would be like your checking account. It can't create a lawsuit on its own. Cash, jewelry, investment accounts. They're not going to cause a lawsuit, but they definitely can be taken in a lawsuit. An inside asset would be everything owned in one entity, and then an outside asset would be everything owned individually or by separate entities. And those are the different types of assets we've got. The definition of a legal entity is this: an association, corporation, partnership, proprietorship, etc., that has a legal standing in the eyes of the law. A legal entity has legal capacity to enter into agreements or contracts, assume obligations, incur and pay debts, sue and be sued in its own right, and to be held responsible for its actions. Now, here in the United States, we do business in one of four ways. You've probably seen these different ways of doing business.
Yep.
Dr. Allen had an LLC that was taxed as a C Corp. And a lot of people get confused by this because they say, aren't an LLC and a C Corp different? And yes, they are. But an LLC has to be taxed in one of those four ways. Now, you can have a corporate structure without the LLC protection. But if you don't have that LLC protection, you really have no protection, because an LLC will protect assets inside of the entity from an outside lawsuit. Now, let me show you how Dr. Allen was structured to show you how this came about. He owned his LLC C Corp on the left there, his building, his equipment, his practice, all inside that LLC on the left. Then he owned his home, his cash, personal property, rental property, and so forth in his own name or jointly with his spouse. Now, in the example I gave, where did the lawsuit come from? Did it come from the business side or the personal?
The business side.
Yeah, you're right. Some people get confused by this because they think, well, it's not on the business premises, but no. He told that secretary to go get those sandwiches. So the business was the cause of that lawsuit. And that means that's an inside lawsuit to that LLC on the left there. And everything on the left was at risk because of that. But because he was a closely held corporation, in fact, he was the only officer, the judge was able to pierce the corporate veil and now go after all of his personal assets as well. And so really the question is, what does this structure really protect?
Yeah, I've often been confused about that one.
Yeah,
it's. Or anything if you're really a sole proprietor.
Yeah, well, it doesn't matter if you're sole proprietor, partnership, C Corp, S Corp. If it's a closely held corporation, the judge will name personal assets as well if he deems it necessary. So really, this structure protects nothing. And like you said, Doctor, most of us are confused by this because this is how we've been told to structure ourselves. But we're all exposed and we don't realize this. And when you really look at it, the doctor was set up backwards. What if he would have slipped, that somebody would have slipped it and fell at the doctor's home and hurt themselves and decided to sue the doctor? Well, yeah, they could have taken the home and the cash and the personal property. Everything on the right would have been at risk in that scenario. But when they tried to sue the corporation, they couldn't do it, because you cannot name an outside entity in the United States if it didn't cause the lawsuit in the first place, even though that corporation was in the doctor's name. Couldn't be named. So what if he would have taken his home and his cash and his personal property and everything on the right there and put those in their own entities? Now when the judge pierced the corporate veil, there's nothing that could be named, because again, you cannot name an outside entity in the United States unless it caused the lawsuit in the first place. And we're not talking about hiding things. You can be very open with it. I mean, you can go to court and say, yeah, I own that LLC that owns my home. And the judge will say, oh, it's an LLC? Okay, great. We can't be named. It's an outside entity. This is how you structure yourself to protect yourself. And do you understand the basics of what I just said about getting all of your personal assets as well as your business assets into their own entities?
Yes, I have heard that before.
Okay, all right. If you understand the basics of that, you understand the basics of asset protection. And I'm going to talk a lot more detail about why it works and the Supreme Court precedents behind it. But before I do that, I just want to talk to you a little bit about a couple of tax deductions that have been Great for different doctors that we've dealt with, all the doctors we deal with actually. The tax deduction I'm talking about is IRS Section 280A. Now, IRS Section 280A has been around for about 30 plus years now. It was first put into place in 1984 for the 1984 Olympics. And what it allowed people to do, and what Congress allowed people to do in Southern California, is rent their homes out to someone else up to 14 days a year and not claim that as income. And they did this for 14 days because the Olympics are 14 days long. In Utah, here, in 2002, for the Winter Olympics, my aunt rented her home. She lives up in Salt Lake, and rented her home for $14,000 for the 2 weeks of the Olympics. She didn't have to pay income tax based upon this provision. But, really since 2002, I really have no reason to rent my home out. And number one. Number two, I honestly don't want to rent my home out. And so it wasn't very practical for me, and I found that to be the case with a lot of doctors I spoke with. But we ran into an accounting firm called the ABA Accounting, one of the largest accounting firms in the country. And what they told us they're having their doctors do is to rent their homes to their entity for business meetings. Okay, now as a business owner, you're supposed to hold at least one meeting a year. Well, the IRS says you can hold as many as you'd like, just be reasonable with it, and one a month is very reasonable to have a meeting about your business. You could also throw in another one in July for the 4th of July and an extra one at Christmas for Christmas. And these are meetings just with the shareholders. It doesn't have to be the whole office, just anybody who's involved in it. If you're a sole proprietor, it could just be you and your wife talking about it. But what ABA Accounting says is don't hold that meeting at your office, don't hold it at a restaurant, don't hold it at a hotel. Do it at your home, and now you can rent the home to the business for a business meeting. Okay, now even you, Harrison, can take advantage of this if you have an entity structured properly with the right purpose involved, and that is for asset protection. We can create an entity for asset protection that you'd have to have meetings about, so you could definitely take this deduction as well. But let me kind of show you how it works real quick. In this example, I used a 3,000 square foot home, and I priced it at 50 cents a square foot. In Utah, that's about right. How the IRS figures your per square foot cost is take a local Hilton or a Marriott or a nice hotel in your area or even a nice resort area and take a room there and divide the square footage of the room by a midweek rate. That'll give you a per square foot cost. 50 cents a square foot's about right here in Utah. So in this example, 3,000 square foot home, 50 cents a square foot, that's $1,500 a day. I can rent that home to my business for my business meetings. If I do it 14 days a year, that's a $21,000 deduction I can take. And why does that matter? When I'm filling out my 1040 form on line 12, it asks me if I have a business profit or loss, and that would go in there. And if I'm making $200,000 a year, I'd owe about $70,000 in taxes. By taking the $21,000 off the top, I'd only owe $62,650. I just gave myself another $7,300 simply by doing something that the IRS requires me to do, and that is to have my business meetings. Now, you have to have an S Corp, C Corp, sole proprietorship, or partnership put together to take advantage of this, and you have to keep minutes of the meetings. But again, these are legitimate purpose of having a discussion at your home about your business, and you can take this deduction. Now, I'm sure you've got a lot of questions about that, and I'm going to touch on a few more deductions as we get going here, but understand when you become a client of ours, we have full-time tax strategists here, attorneys that specialize in tax strategy, that we can, once we learn and understand you as a client, we're going to help you implement all of these different deductions. And it's just part of the service of what we do, and I want you to understand that. So any questions on what we've talked about so far?
No, actually, it was pretty clear. You explained very, very well. Yeah, it's good.
Okay, well, great. Thanks. Well, let's talk about living trust. A lot of doctors, when I talk around the country, they believe that a living trust can protect their assets in a lawsuit, and they can't because they're considered revocable entities or changeable entities. But when you die, they become irrevocable, and they will protect you against probate. Now, probate is a court, and if you have a will guarantees your estate will go through probate. A living trust will take the place of a will. And according to the state, you're still alive with a living trust, so it won't have to go through probate, and there's some real problems with that. Number one, probate's time consuming. In some cases, it can take 6-7 years. Anything that's taking that long in the court system is going to get expensive with fees and so forth. And lastly, there's absolutely no privacy when it comes to probate court. And this is the biggest problem that doctors run into, is the no privacy, because you have to understand, because of what you've accomplished and because of your profession, there are people out there when you pass on that their job is to go down to the courthouse to find out exactly what you owned when it's in probate and who you gave it to. So let me ask you this. If you've got a target on your back, guess where that target just shifted to? People you love the most, right? And this is the biggest problem with probate, is because people can see your business. They know exactly what's happening because it's public record. And there's really only two ways to avoid this. You can guess the best way is just simply don't die. But obviously that's not going to happen. So the only way to protect your estate from going through probate is to get a living trust. And now a living trust can be an expensive document. Here in Utah, you'll probably spend about $3,000 to $5,000 to put one together. Now, Legally Mine specializes in living trusts as well, and we're going to get into the details on that. But it is something that we all need, and it's not for you. It's for those you love the most. And we need this before we die, but unfortunately, we just don't know when that's going to happen. So it is something that we highly stress people to look into. Plus, there's some tax benefit that can go along with it as well. And that's why we bring this up, is because it is very important that people look at this before they pass on. Any questions on the living trust?
Yeah, I've never really heard probate before, and you went through it kind of quick. Can you just kind of slow down a little bit on what probate really means?
Well, probate is a way that it kind of puts everything on hold and holds everything to sets it aside so that people can't come and break down the properties and the assets of that particular deceased person, so they can organize it and disperse it to their heirs or pay taxes on the properties and all that and so forth. So it creates just a hold on everything, so people don't just come in and go crazy on, for example, if my children, I have 5 children, by the way, and if my children had and let's say my wife and I passed on and we had a will, well, our estate would go into probate. And it would be on hold there, and our children would come down to the courthouse to find out what each one received from mom and dad. And let's say my son maybe, for example, has a drug problem. We don't want to encourage that type of activity by giving him a big chunk of money. So we're going to leave him out of the will. Well, he's going to go down to the courthouse, and the judge is going to say, well, yeah, you don't get anything. But he says, okay, I want to see what my brothers and sisters received. And because it's in probate, he can see exactly what they got. And this is the biggest problem with probate. So it's just so it's just not a mad rush to take everything. It just kind of puts everything on hold until the state can settle it out. But by having a living trust in place, the person that is the executor of the living trust has the authority and the capacity to organize and do things without the state being involved.
Okay, that makes sense. Thank you so much.
All right. Hey, you got it. An important document to have, and everything must flow through it, and that's the biggest thing I find with living trust. People get them set up, and they get new properties or new assets later in life, and they don't put them through there. So if they're not going through the living trust, they'll have to go through probate. So anyway, you just got to make sure you stay on top of it, and that's what we do as part of our service as well, is to make sure any changes in your life happen, that goes through there. So. All right, well, let's talk about lawsuits. In the beginning, I told you that we had a real epidemic here in the United States. I didn't realize how bad it was until I saw this graph. In the United States makes up 5% of the world's population. And, take a guess what percentage of lawsuits worldwide come from that small U.S. population.
90%, 95%, I know.
It's funny you say that. I ask that question all the time, and I always get 80, 90. I had a doctor the other day tell me 100%. And, we had a good laugh about that. But what it tells me is we just don't have a lot of faith in our system. And unfortunately, we're pretty close. 94% of all lawsuits worldwide come from that small U.S. population. And I always ask, why is that? And I'll get back, there's a lot of attorneys. A lot of money here, a lot of greed. Well, yeah, that's right, but there's a lot in countries around the world too. And so why is this? And as we look at it, we realize we have a lot of attorneys, but our attorneys are in the wrong places. Who do we elect into public office for the most part? Attorneys, right? In fact, in Congress, 70% of our elected officials are attorneys. So if you write the laws and you judge the laws and your profession will benefit from those laws, how are you most likely going to write the laws? Okay, it's human nature to write them to benefit you. Oh, go ahead. I'm sorry.
Like some sort of conspiracy theorist over here. I'm just kidding. It's true.
Well, it's interesting because you have to understand the trial attorneys have truly a vested interest. They have a vested interest. And other countries look at our laws and laugh at us because other countries there are repercussions for filing a lawsuit. Not in the United States. You can file a lawsuit. There's no repercussions. Is that crazy? You're right. And they laugh at our laws because they truly encourage lawsuit. It's just what it is. And there's no other explanation. Why 5% of the world's population should have to 94% of the lawsuits? We have a real problem here, and it's not going to get solved anytime soon. And the problem is it creates a huge attitude problem too. People, we saw this in the USA Today that said, "How are you going to get rich?" And people here in the United States pulled in and said, "Well, I'm going to inherit. It's got to make us feel good about our kids, right? Just waiting for us to pass on so they can get our money. Number two, how are we going to get rich in the United States? I'm going to win the lottery. And number three, sue somebody." It's interesting. The top three answers, it's not, I'm going to go to school, get a good education, start a business, the American dream that we talked about earlier. But no, that's not how we're programmed anymore. We're programmed to look for those who have made it and take it from them. And unfortunately, guys, that's you. Because of what you do for a living and what you've accomplished, you have that target, and it's so easy to sue a doctor. There's so many different things that can happen that can cause problems. And when you look at this, none of these three answers said, "I want to work hard to get my money." Every one of those said, "I want an easy way out." And it's really exacerbated by the fact that attorneys can advertise and they do it freely. When was the last time you heard something about mesothelioma?
Yeah.
Probably last time you turn on the TV, right? They're all over the place, and that's just one of many. And a lot of people say, well, they're helping the victims, and yeah, the victims are benefiting, but if you look closely, the big money is going to the attorneys. So this is the reason why it's not going to change, because they have a vested interest, and that's huge, huge business. And this is why they just don't change, and why we've got the problem here in the United States. But I don't know what the other explanation is. That is what it is. And so, when we look at we talked about vicarious liability through employee actions and through people that work with you. Do either one of you have a business partner?
No.
Yeah.
Okay. Okay. Well, understand your spouse is a partner. Your children would be considered partners. If any one of them are driving in a car that's registered to you or somehow connected to you, you're going to be, and they get sued, you're going to be named if something happens to them. It's through vicarious liability. I just want to bring up the point that it's not just you have to worry about. It's all those around you, not employees, your family members and so forth. And it's just something it's another reason why asset protection is so important for doctors and those in your profession. So now I know I've talked a lot about some scary things out there, and these are real things that are happening on a daily basis, and we see it every day because of our clientele and the base that we have. But we want to bring that up and make sure you understand that the realities here. But at the same time, we want to show you that there is a light at the end of the tunnel. And there's a solution that's been put together, and the solution came with what's called a family limited partnership. Now, most people have never heard of a family limited partnership, so let me give you a little background on where it came from. 1914, there was a man named Frederick Weyerhaeuser. He was owner of the Weyerhaeuser Company. He owned this company in his own name, lock, stock, and barrel. It was worth a few $1 billion at the time, one of the richest men in the world. And in 1914, he was an old man and was about ready to die. And the reason why this was significant was that in 1913, Congress passed the 16th Amendment, which was the first time that the federal government could tax us as individuals, which included a state tax. So the IRS was pretty excited about this because they were going to get a few $1 billion out of this situation when he died. But somebody at the IRS got smart and said, now wait, if we take half of that company's going to go out of business. And we're talking about tens of thousands of people out of work, plus they wouldn't be paying income tax anymore. So they said, well, this isn't a good idea. But they couldn't just tell Weyerhaeuser to forget about it because they just created these laws. So they started looking around. They talked to some associates in England who told them about the family limited partnership, and they said this will work in this case. Now, the family limited partnership is built with a general partner and limited partners. In the United States, if you want to have total control of a company, you have to own 51% of that company, okay, generally. With the family limited partnership, you only had to own 1% to have total control of the company. And so what the IRS did is they created a family limited partnership, made Frederick Weyerhaeuser the general partner, gave him 1% ownership, gave his sons the other 99% as limited partners. They put all the assets in it, and when he died, the IRS stepped in and took 1% of Weyerhaeuser, and Weyerhaeuser didn't skip a beat. As a matter of fact, they're still with us today. But since 1914, the IRS has been doing this to save these solely owned companies so they wouldn't go out of business. But nobody else had really seen these before. But in 1960, our founder, Jay Minton, came along and said, now wait, who should be liable in one of these family limited partnerships? And he reasoned that the limited partners had none of the control, so they should have none of the liability, and the general partner had total control, so he or she should have total liability. He also found something interesting. He found that you didn't need a family member to be a partner with you. As a matter of fact, you didn't need a partner at all. You could be the general partner and limited partners. Now, courts frowned upon that later, so what we started to do was to create an entity for the client to be the general partner and then make the client the limited partners. In essence, they own the entire thing, but it was just broken up between an entity and themselves. Okay, now let me show you how my wife and I are structured to show you how you do this. We create a family limited partnership, and we created an S corporation to be the general partner. Now, my wife and I have decided to own that S corporation 50-50, equal ownership, so equal control. We gave that S corporation 1% ownership, but with the family limited partnership, it's only 1% is all you need to control it. Then my wife and I took 49.5% each for a total of 100% ownership. Now, if I put all my assets into that family limited partnership and I get sued, theoretically, how much can be taken in that lawsuit?
1%.
Yeah, and unless my name's Bill Gates, who wants 1% of my assets? Think about it. What is 1% of your assets really worth? Is it worth suing you for 1%? In most cases, yeah, it's not worth it, right? We talked about in the beginning about motivation in these suits is money. The lawsuit will not happen if there's only 1% to gain. And this is the start of asset protection. This is why these are so powerful. And it gets better than that, actually, because there's some IRS implications and so forth. I'm going to talk about those. But I want to show you what you can do within these family limited partnerships tax-wise. And this would be for both of you because Harrison, you're an independent contractor. You can take these deductions as well. But it's called income shifting. Now, I've got a 20-year-old daughter going to school, and I have to pull out about $20,000 to help her get through school every year. Now, I could give that money to her post-tax, but I would have to earn $35,000 plus to give her $20,000 because I know I'm going to get taxed right off the top about $10,000 to $15,000. Well, I made her a limited partner in my family limited partnership, and now I can shift that money to her pre-tax. I no longer pay taxes on that $20,000. She does. But what's a full-time student going to pay on $20,000 after expenses? Nothing. She paid nothing on that, and I saved about $15,000. About $13,000 is what I saved. But we have a gentleman in our office who gives $1,000 a month to his elderly mother to help her get by. It cost him $4,500 a year to give her that $12,000 in taxes. Made her a limited partner, shifts it to her pre-tax, no longer has to pay the taxes on it. Her tax is $500 a year on that $12,000. He knows that because he pays it for her. But what would you rather pay in taxes, $4,500 or $500? I mean, it's kind of a silly question, right? It's just about being smart with the way you use your money. And since you have children, you can do this when they get to, once you turn 18, it's unlimited of much money as you can give. Under 18, there's some things that we can show you, and this is what our tax attorneys will do to help you take advantage of this, even with children under 18. And you can do this with children, grandchildren, elderly parents, anyone you want to help out with. You can shift that income, and you wouldn't have to pay taxes on it. So great benefit to you. Now, you can put any legal asset into these family limited partnerships, like your home, your real estate, cash, personal property. Income can all flow within that family limited partnership, and it would be secured like we talked about. Now, just so you know, back in 1960, this was all just a theory. It had never been proven in a court of law. So we were putting all of our clients into this. It made a lot of sense. And they were being sued. And quite frankly, at the lower court levels, we were losing every time. The judges were ordering all the assets out and breaking this. They'd never seen it before. So, fortunately, it was being appealed to the federal level, and we were winning every time, until in 1972 in the Ninth Circuit Court in San Francisco, the judge ruled against the family limited partnership and ordered all the assets out. Well, this was a great thing for asset protection, but because it was appealed to the Supreme Court. This was the first time the Supreme Court had taken a look at the family limited partnership for asset protection, and in 1972, the Supreme Court ruled 9-0 in favor of the family limited partnership, which cemented it as an unsuable asset protection tool. And since 1972, we have never seen a family limited partnership broken as long as it was put into place before the lawsuit was filed. Now, if you're in the middle of a lawsuit right now, you couldn't create one of these and put all of your assets in it. That would be a fraudulent conveyance. You'd get in trouble for that. But if you can get it created before the lawsuit is filed, you can't break it. It's unsuable. Again, you take away the motivation. There will not be any law. There won't be a lawsuit. Any questions on that we talked about?
No, it's just brilliant.
Okay. Well, it gets better. Wait till you see the next part, because it took away even more motivation. Because the trial attorneys looked at this court case at the Supreme Court level, and they realized we're going to lose. And if we lose this, we're not going to be able to sue these type of entities. So what they did, they started looking for a loophole, and they found something called the charging order. Now, without getting too technical, inside every document in the United States there's something called the distribution clause. The distribution clause says if you own 100%, you get 100% distribution of cash. If you own 50%, you get 50%, and so forth. Well, what the trial attorneys did is they changed the wording in the distribution clause so they couldn't take your real property like your home or your equipment and so forth. But what they did is they gave judges the right to force a distribution of cash. They could come after your money now. Let me show you why this was a big problem back in 1972. So, James, let's say I sue you for $1 million. And the judge comes in and says, James, you've lost the suit. You owe Dave $1 million, but you've got all of your assets in a family limited partnership, so I can't take your home or your real estate. But every time you make any money, I'm going to force you to distribute a percentage of that to Dave until you've paid him $1 million. In essence, the judge is going to tell you what you can make for really the next foreseeable future until you've paid me $1 million cash. What do you think about that?
Not fun.
Yeah. Yeah, there was a huge loophole there, right? They could come after our cash. Our property was protected, but not our cash. So, we had to go to work and change a few things. So what we did is we changed the wording in the distribution clause so that only the general partner could order a distribution of cash. In essence, we blocked the judge out. He had no longer jurisdiction in this particular situation because of the wording. Now, we had to get this approved by the Supreme Court. So we sent it in and got a private letter ruling back in 1974 which approved this. So let me show you how this changed. So, James, I sue you for $1 million. Judge comes in and says you've lost the case. You owe Dave $1 million. He says I can't touch your home or your real estate because it's in a family limited partnership, and I can't force you to distribute any money to Dave, so it's up to you whether you're going to pay me $1 million. Are you going to pay me $1 million if no one's forcing you to do it?
Let's say no.
Of course, right? Of course not, right? Well, how do you think that makes me feel? I actually spent all this time, effort, money trying to get this court case put together, actually won the case. You owe me the money, and now you don't have to give it to me. Well, I'm not too happy about this, but guess who else wasn't happy about this?
Oh, and other attorneys, the prosecutors.
Yeah. Yeah, you're right. The trial attorneys were not happy at all. They could see they were losing, but it was bigger than that. The IRS was not happy about this because they could see that if somebody sued a family limited partnership, that person would never pay that person because they'd never have to distribute. The judge couldn't force it, which means if I would have won $1 million judgment against you and you paid me that $1 million, I would have to pay income tax on that. And the IRS could see that you were never going to pay me. So I wasn't going to pay that tax. So what they did, because they didn't want to lose out on that money, is they came up with the IRS ruling 77-137, which states, now, gentlemen, listen closely. This is important. A plaintiff using the charging order will have to pay income taxes on any monetary judgment, even if there is no distribution from the defendant.
Jeez.
Okay, let's do it again, James. I sue you for $1 million. Are you going to pay me if you don't have to?
But no. But I have to
No,
pay taxes on the
No, guess who knocks on my door next? The IRS looking for about $400,000 of money I will never get. Okay, you don't have to pay the taxes on it. The plaintiff, the plaintiff has to pay the taxes on it. This was the This is called, actually, we call it the what do we call it? The revenge clause is what we call it, because it truly is revenge against these people filing these frivolous lawsuits or any lawsuit against you, because if they sue you and they win, you're not going to pay them and they'll owe taxes on money they're not going to get. Now, most attorneys have no clue of this, okay? Just like you focus in different parts of your business, they focus in different parts of law. They don't understand this. In fact, in the mid-1970s, a bunch of attorneys challenged it because they'd never seen it before, and guess what? Their clients won their cases, didn't get money distributed to them, and they owed taxes on that money. So guess what they did to their attorneys?
To the attorney.
Yeah, they sued them, and it created precedents. Okay, all we have to do is show an attorney this, show him the precedent, show him the Supreme Court ruling, show him the IRS ruling. What's the purpose of suing you, James, if you're structured the way we're talking about? There's nothing. Okay, in the beginning we talked about the money was the motivator in these lawsuits. There is nothing to gain, and once they get into this and they understand what they're really up against, they will drop these cases. And this was really the final nail in the coffin for the trial attorneys because they cannot sue them. But you know what's crazy, guys, is that this has been around for 40 years, and you've never heard of it before. And there's a good reason for that. They don't teach it in med school. They don't teach it at any school in any business schools. They don't teach them even in law school. This isn't taught because they don't want you to know about it. Because you think about that. They cannot sue this, and they will move on to something else. And this kind of leads me to my next point. You go to your local attorney and have him create a document for you. He's probably not going to understand this, so he's just going to use software to bring up the document. Now, is that document, just so you know, the document is written by the trial attorneys, and that's what the software he purchases. You know, so how do you think they're going to write that software? Are they going to write it to benefit you or benefit their profession? It's going to be them. Yeah, we reviewed over 3,000 doctors' documents last year alone. Not one of them written correctly. Every one of them had wording in it that if they got sued, they could force distributions of cash, and they would lose money in those cases to the total amount that was sued for. So it's a really scary situation for people because they think they're protected and they're not. But if you're set up and structured properly and you use the right wording, unsuable. Cannot break it. Now, in the mid-1980s, there were a group of former employees of ours that came to us and asked us to help them create a document that was better for business purposes. The Family Limited Partnership is a great document, but it's expensive. It can be $5,000 to $10,000 to create one. And for businesses, that wasn't very easy thing to do. So what we what we did is we helped them create the LLC. The LLC is written very similar to the family limited partnership. We just used a lot less wording, and attorneys like to charge by the page. And so by doing that, we were able to keep the cost way down on this. Now, it's written almost exactly the same as far as the asset protection is concerned. But so understand that the remedy for getting assets out of an LLC is the same as the family limited partnership, and that's the charging order. But as long as your distribution clause is written correctly, the same protection as a family limited partnership. And that's why we use LLCs as well, because they can't be broken, just like that family limited partnership. Now let me go through an example here and we'll start winding down. Let's say I take all my safe assets and I put it in a family limited partnership. That's cash, jewelry, checking accounts, investment accounts, things that aren't going to cause a lawsuit on their own. Then I put my home in its own LLC, and I put my real estate property in its own LLC. And let's say that real estate property catches on fire and somebody gets hurt. Well, I'm going to probably get sued in that situation. It's going to be an inside lawsuit to that LLC on the right there, and I'm going to lose some value within that property. But really, what am I trying to do? Trying to protect everything else. And because these are outside entities, they can't be named in this lawsuit. If these were separated and just put in my own name, that FLP, my safe assets and my home were just in my own name, and my company got sued, absolutely they could be taken. But in this case, they're separated out, can't be touched. Let me give you another example. Park City. Have you guys been up to Park City and skied up there at all, or been up to that area?
Yeah, a long time ago.
Yeah.
Okay.
I remember this presentation too. This is a fun one.
Yeah, when you go to Park City, when you jump on the first lift, it's called Payday. Right on Payday, they put a plaque that says Payday LLC. That lift and that part of the mountain is an entity. Then they took if you take Payday up to the top and ski across Little Meadow over to another lift called the Widowmaker, they put a plaque called the Widowmaker right there, and they made that an LLC as well, an entity, that mountain, that particular run. So if I take Widowmaker up to the top and I'm skiing down and I slam into a tree and kill myself on the Widowmaker, who can my wife sue? Can she sue Payday? She can't, because that's an outside entity. Can she sue the Widowmaker? Well, yeah, Widowmaker caused the lawsuit, but the Widowmaker doesn't make any money, and you can't take the real property in an LLC. You can only take 1% of the cash, and it makes no money. When I bought my lift ticket, I paid Park City Ski Resort LLC. Park City Ski Resort LLC makes all the money, takes none of the risk. This is how we've set up ski resorts all around the country. If they weren't set up this way, they'd be out of business in 30 days. It's such a high-risk industry, but that's what we do there. One last example. We had a doctor get sideswiped in a Walmart parking lot down in Arkansas, and he decided he was going to sue Walmart. But when he started digging, he found that the Walmart parking lot was in one LLC and the Walmart store was in another LLC. And how are you going to sue a parking lot? I mean, there's nothing to gain there. You can't take the real property. It makes no money. Don't you think Walmart knows a little bit about asset protection?
Wow.
Yeah, you bet. They know what they're doing. So if I take my whole family, put them in a big tank, and someone gets lucky and gets a grenade in there, and well, we're all gone together if we're at war together. But if I put them in separate tanks, someone gets lucky and gets a grenade into my tank, well, I'm gone, but the rest of my family is protected. And this is what asset protection is about. Get all of your assets into their own little individual tanks. So if someone gets lucky, and they get lucky all the time, minimize the damage. Make sure you contain it so that it doesn't destroy everything you've worked so hard to attain. And you can do this by entity structuring. Typical structures, most of us have our business on the left there, own everything personally or jointly with our spouses. Again, it just protects nothing in this scenario. True asset protection starts with a living trust. Now, like we talked about, a living trust will not protect your assets in a lawsuit, but it will protect you against probate, and everything you own should flow through that. Your business, what you should do is take your equipment and your building and strip that out of the business. The only thing that should be left in that business is your goodwill. Your goodwill is your patient base, and that's a non-quantifiable asset that cannot be taken or named in a lawsuit. So there's no reason to sue that business. There's nothing to gain there by suing it. Next, take your safe assets, put them in their own family limited partnership, and then get all of your high-risk assets like the equipment, like the building, like your home, put them into their own LLCs. You separate it out like we're talking about. That is rock solid asset protection with Supreme Court precedents. Okay, and that's a pretty simple little structure there, and this is what we do day in and day out here. Now, there's some rules you have to follow. We've talked about establishing the entities before the lawsuit's filed. Divide the high risk and safe assets, and that's important because the safe assets you can lump together, but the high risk assets, I hope you understand now, if you have multiple properties, why you can't put them all together. Because if something happens to one of them, they all can be taken. They all can be named. So you have to separate the high risk assets out. And then make sure the entities get power to distribute to the general partner, not to the judge, a very important part of that. And then maintain the minutes and state registrations, another very important part. So, when we first started going around the country, we'd educate doctors on this, and they would take this information to their local attorney and have them set them up. Well, we found out there's some real problems with that. Most attorneys know very little about asset protection. Matter of fact, the American Bar Association did a survey, and they have found that only 0.5% of attorneys nationwide specialize in this. So what was happening is the entities that were being designed were not really serving their purpose. They were leaving these doctors exposed. And if you went to someone that knew what they were doing, it's a very specialized field. People are charging amazing and exorbitant fees. We did a survey of just some asset protection companies across the country, and we found $3,000 to $5,000 for a living trust. C Corp, $1,000 to $2,000. Family limited partnership, $10,000. LLCs written properly, up to $2,000 a piece. So for this little structure, we're talking close to $30,000. And most doctors look at that, and that's a huge deterrent. Now, it's a drop in the bucket if you get sued, and I think you understand that. But it's a lot of money to pull out of pocket. It's the reason why doctors are not protecting themselves, if they can find somebody who can do this, and it's the reason why the attorneys are having such a heyday. So what we did a few years ago is we came up with a solution. To be honest with you, in the beginning, it wasn't a great solution. We had this big book that we'd give to the doctors and basically tell them to do it on their own. Well, I think you can see the problems with that. Number one, it's a lot of time involvement. You don't have time for that. Number one. Number two, you're not attorneys, and so there's a lot of intimidation. Am I doing it right? Am I filing this properly, and so forth? So it wasn't a good solution. So about 9 years ago, we threw out those books and we brought everything in-house, and we hired in-house attorneys, in-house paralegals, in-house researchers. And now we take our clients from step A to step Z, and we really take care of everything along the way. Legally Minds educate over 100,000 people nationwide. The event you went to, Harrison, is one of probably about 400 we do a year. So more than every night of the year, we're out there doing this a couple of times a night in some cases. And speaking to doctors specifically, we do a few real estate people, but mostly doctors. We've made some amazing affiliations through the years. Bank of America, Harding Financial Services, ABA Accounting, all national firms we do business with on a daily basis. We have currently over 20,000 clients and growing, and we have an A-plus rating with the Better Business Bureau. And I don't know if you have dealt with the Better Business Bureau, but if you're willing to pay what we call their extortion fee and be accredited, they'll give you a higher rating. Well, we did this without paying that fee. We have an A-plus rating with the Better Business Bureau. It just kind of shows you what kind of company Legally Mine is. Now, Harrison, you probably know the pricing. You've probably told James as well, but I'm going to go through it again to make sure that you understand what you're paying for and what you're getting. What we do is we break our pricing into two parts. The first part is the planning stage, and it's called Premium Plus. Premium Plus is a one-year agreement that we're going to that costs $1,800, or you can break it up into monthly payments of $150 a month. We don't care how you do that, but what we do for $150 a month is pretty amazing. We do an asset and document review of all of your existing documents. Then we take those, if there's something that's written improperly, we're going to amend that and file that with the state for you. Okay, next we're going to create a customized blueprint for you. This will be done by an attorney who will then go over it with you step by step of exactly how you should be structured. This is a sample blueprint, living trust down to that holding company, and this is important. The holding company is actually placed in Alaska because Alaska has the strictest charging order in the United States, and if you have property that's located in Utah but it's registered in Alaska, the Utah judge has to use Alaskan law, and it's unbreakable in Alaska. And just so you know, a Utah entity can be broken. There's a few states, about 38 of them, that you can break entities, and you can do that based upon Utah law. So don't ever create one here if it doesn't have an Alaska holding company attached to it, because the judge can break it. But if it's in Alaska, can't be touched, cannot be broken. Those LLCs at the bottom there, we're going to put those in Utah, but the reason why we do that is because it's cheap in Utah. It's only $15 a year, but it doesn't matter where we put those LLCs as long as they flow through that holding company in Alaska, and that's where you're getting the real protection at. Now, a lot of people look at this and they think, well, that's going to be a lot of tax returns. All of these are disregarded entities. There's only one tax return you have to file, and that's Alaska, and they don't even have state tax up there, so it makes it very simple for your accountants to take care of this structurally. And that leads me to my next point. Like I told you in the beginning, we have full-time tax strategists that are attorneys here that work on tax plans. Once you have a blueprint created, now they can customize that to you. And this can be pretty significant, what we can do for you. This is an example we did of a dentist up in Boston a few years back. We did a blueprint for, a tax plan for him, and by using his home for the 280A deduction, we saved him $11,000 in taxes. He was sending 3 college-age children to school, spending $118,000 a year on them. By shifting the income, we saved him $46,000. First year overall, we saved him over $58,000. And now, and just so you know, he was pretty happy about that until he realized that he'd been way overspending for years in the past. But since then, we've put him into our Advanced Tax Strategies program for high-income earners, and we're able to find him a lot more deductions. And this is what we do as part of our service. Now, not everybody saves $58,000 and more. But what we can tell you is, because most doctors we talk to, their tax preparers are just simply that, tax preparers. They're not really looking for deductions. We can save on average of about 10% of your gross income. And so if you guys, Garrett told me that you're in about the $200,000 to $300,000 range, we're talking $20,000 to $30,000 a year just in tax savings at the minimum is what we should expect on that. And that's just new money to you. You can use that for investing. Use that for college education, travel, whatever you want to do. That's just new money that's going to come every year, year after year after year. And Legally Mine, any deductions we're going to talk to you about, stand firmly behind every one of those deductions. We're not talking about gray areas here. We're just talking about being smart and doing it the right way for those tax deductions. Now, as part of the Premium Plus, we also observe all the formalities, and this is an important part of this because you don't have time to handle all this. So we're going to take care of the registrations. Now, you're going to pay for those registrations, but that's why we put them in Utah. It's only $15 a year. Make it inexpensive for you. But we'll take care of that. We're going to make sure your annual meetings are taken care of. And then the minutes for those meetings, we're going to make sure you get those done. And then also, you're going to have access to our attorneys all year round. If you ever have questions concerning asset protection or taxes, you can call our office, set an appointment with an attorney, and there's no extra fees you'll be charged for that. And these are specialized attorneys for exactly what we're talking about. No fees. It's part of that Premium Plus. One thing I don't put on this that I should put on there is all of your registered agent fees are going to be taken care of as well. You won't pay anything more to have entities created in Alaska or Utah. So those are all included with that, no extra cost. Lastly, if we are in your business after the first year and you see the tax benefit, you see the asset protection benefit, and you want us to continue to manage your account, because this is really where we make our money, is managing accounts moving forward. If you want us to manage it, we can do it for you at $150 a month moving forward. If you want to do it yourself, you can do it yourself, and you'd never have to pay us another dime for any of this. But most of our clients say, look, I understand that it's a hassle, and I'll just let you take care of that. Plus, I'm saving them $10,000 in taxes. Why not take $1,800 of it and just pay it? So, but if you're very organized, or if you've got people at your office can do it, they can do it as well. But by having us manage it, every year we're gonna do an annual blueprint and annual tax plan. If anything changes to tax law with the asset protection law, we're going to automatically change it for you, and that's part of that service. Now, that's what Premium Plus is. That's the planning stage, and that's what you're buying up front. Once we get that plan put together, now we have to create the entities. And if you remember, this can be the expensive part. So what we did is we tried to make it as inexpensive and easy as possible, and we charge a flat rate of $1,200 per entity. And by the way, this includes a living trust and a family limited partnership, both $5,000 to $10,000 documents. That alone is a huge value. But and by the way, our living trusts all include a last will and testament. So if you need a will, we can put that into place there as part of that, and it's included. And I don't know anywhere in the United States you can get a living trust created for $1,200. It really is unheard of. And the reason why we do it is because this is all we do. It's our focus, and we build our business around it. Now, a lot of people look at that and they say, well, that's great, but I need 10 entities. That's close to $15,000. Other doctors look at us and say, well, I only need 1 or 2 right now, but in my lifetime, I know I'm going to get more assets, and I don't want to have to pay $1,200 because it could start adding up. So what we do when we go to these meetings, and Harrison, you were there, so you saw this, we actually give some incentives while we're at the meeting. Now, because this is after the meeting, I'm not 100% sure if Garrett's going to be able to offer those, but I can break it down for you and show you what we did there. The lifetime cap is what we offer at the meeting of $6,000, and what that means is once you pay for 5 entities, you pay for no more in your entire life. So if you need 10, you're not going to pay more than $6,000. If you only need 2 right now, but you're going to create you're going to create more in your lifetime, you'll never spend more than $6,000. That's what that cap is. And James, you didn't go to the meeting, right? It was just Harrison?
It was just Harrison.
Okay, all right. Well, there might be some things that Garrett can work with you on. It's normally $8,000. We give a cap on these webinars, but talk to Garrett and see if there's something he can do if you're interested, because it's still a great value at $8,000. But I just want to let you know that that's what we do when we go to the events. And also, one of the incentives we give is our tax savings guarantee. And again, you'll have to talk to him and see if it's something he can give afterwards. But the tax savings guarantee basically says if we can't save you at least $6,000 in the first year in tax savings, we'll cut you a check for the difference. So after 1 year, you're paid up in full for asset protection, and then after that, you don't have to pay anything more if you purchase the cap. So talk to Garrett about that, but I bring it up because regardless, you're going to save money on taxes. But it's always good to get that guarantee attached to it. And the reason why we do this, obviously, group pricing, talking to a big group when we're out on the road, but mostly we do it because we want people to take action. So many people come to these and they realize that they're not protected and they want to get it done and they're blown away with what we can do, but they leave and they don't get it done. And it's as you can see, and maybe a lot of people think, well, I've never been sued, but there's a huge risk to doing that. All it takes is one wrong lawsuit. You can ruin everything, and everything can be taken. And so we say, look, don't waste your time. Don't take your time in making a decision on this. Do it while you're thinking about it. And, the pricing we've given I think is very fair, number one. Number two, it's got Supreme Court precedents behind it. Number three, if you get the tax savings guarantee, you get your money back. I just don't know of there is not a better offer out there. And it's the reason why Legally Mine is the fastest growing, largest asset protection company in the country because of what we do there. So anyway, let me give you some FAQs and I'll finish up. On average, we spend about 60 hours per client. That's our time that we'll put into your account. Your time involvement is going to be about 3 to 4 hours, and that's going to be split up over about 6 to 8 weeks. Once you're done with that time frame, you're done. You'll never have to deal with this again. We'll take care of it moving forward. And I love this last stat, 99% of initial purchasers use the services. What that tells me, because understand most of our clients are doctors, and think how busy you are. We're willing to work mornings, we'll work weekends, we'll work evenings to get you protected. And that's what that statement really says. So anyway, that's my presentation, and that's what I would give if I spoke in front of a group. And so I was grateful for the opportunity to speak with you, you gentlemen. But one thing I do want to bring up before I finish up here is, in 40 years of structuring clients, we have never had one of our clients successfully sued. And I think you can see why. If you structure clients and you have the Supreme Court precedents like we're talking about behind it, there's no purpose in suing you. we take away the motivation of these suits, and believe me, once the attorneys, if you ever get sued, you don't call your attorney, you call us. We call the prosecuting attorney, explain how you're structured, and they get dropped. I can't remember a lawsuit lasting more than 30 days with one of our clients, and this even goes to frivolous lawsuits, because those frivolous lawsuits that you can't lose, they can still take you 2-3 years of worry and have to come with depositions and paperwork and so forth. This eliminates it up front because the attorneys don't want to take the chance that they might win, because if they win, you're not going to pay them and they'll owe taxes on money you're not going to give them. And so, again, set it up properly, get yourself in a position that you take away motivation, there won't be a lawsuit, and that's what we do here at Legally Mine. So, gentlemen, you've got me on the phone right now. Any questions for me while you still have me?
I've just been thoroughly impressed. I gotta say, I'm blown away. I've heard fractions of different presentations like this, but by far you definitely hit a nail.
And they have it all together, right?
So thank you for that. I did have a few questions about what's going on. So you're more so, as far as taxes, you'd be explaining to our own CPAs how to do tax stuff, or would you guys actually prepare our tax documents? I was a little confused about that.
Well, Garrett, are you on the phone?
Yeah, I'm right here.
That's probably a better one for you.
Okay, great. So, guys, what we'll do is we're going to just hang up on the webinar, and I'm going to give you a call right back.
Okay.
So, yeah, we want to thank David for giving the presentation today. It was his 50th birthday. I tried to talk him out of working today, but anyway.
Well, thanks, Garrett. I appreciate that. And, as far as those taxes are concerned, it's with the CPAs and your accountant. Anytime we're not going to do the taxes for you, but we're going to give a complete plan. And like what I give to my accountant every year is I just give her the plan that they've put together for me, and she just takes it and puts it and does it. Now, she never had any questions. Sometimes your accountants will have some questions, and they can call and talk to our attorneys, and that's no fee and no charge for that. So hopefully that answers that question.
Thank you. I appreciate it.
All right, guys.
All right. Hey, Garrett.
Right back.
Well, thanks. I really appreciate the opportunity to speak with you, and Garrett can definitely answer any questions you've got on top of that. But if you have more, I'm usually here at the office. If you have more, you can certainly give me a call here. But again, grateful for the opportunity to speak with you.
Hey,
Yeah,
thanks,
thank you,
David.
All right. Have a great day.
Have a great one.
Bye-bye.
Holy crap.
All right, so this does obviously cost, and obviously so it's protection, but then so it's tax saving from per month for the rest of your life. That's cheap. It isn't much. Cheap. Now the thing is, I don't know what to compare it to. That's the only thing. It's an ignorance, but it seems like it's crazy because no one knows.
They're going to be charging us me at a discounted rate, $550 for just doing CPA stuff. This is way more valuable.
It's more valuable because you can get the tax plan to any CPA and have them plan it.
You are the last party in the conference.